Thank you for joining us. I'm Lauren Baker. We're continuing our coverage of the trial of Christopher Schurr. It's day one of the trial, and we have heard opening statements and the first three witnesses to take the stand. We'll recap all what has happened so far in the trial, but we do want to remind you that we are delivering you the live stream of the trial on a court-mandated 30-minute delay. So what does that mean? Well, 13 on your side was instructed by the judge to stream the trial on this delay so that any sensitive information that is not supposed to be broadcasted, like personal details, can be redacted before it's put on air. There are no other modifications on how we're delivering the trial, and we'll remind you about this throughout the delay of the trial. We're now joined by Andrew Rodenhouse of Rodenhouse Law Group. Andrew is a trial attorney and graduate of Hope College. He received his Juris Doctorate degree from Cooley Law School and oversaw the appeals case of the People versus Ackley, which changed Michigan law as we know it. Andrew, thank you so much for joining us. And we are having some technical difficulties. Andrew will be joining us soon. But again, we're going to be recapping all of the things that have happened so far in the case. Andrew actually joins us now. Andrew, thank you so much for joining us.
Well, good morning, or I guess good afternoon now.
Yes, it's been a very long day when it comes to this trial.
Yeah, we got started pretty much on time. I'm really happy that they did the jury selection last week, because otherwise we would just be sitting through a jury selection today. So they were able to actually get going. Typically, jury selection takes place the first day of trial. So we were fortunate that we could start right away with opening statements.
This is great. And I have a bunch of questions about the jury, but I want to get straight to the trial. You've been watching this trial all morning long. What are your thoughts so far?
I have one thought that I'm really kind of annoyed by, and my annoyance goes to Mr. Becker. I have clients that are charged with possession of tasers all the time, and it's a 4-year felony. They even get charged when they're broken or they don't work or they're not charged. And so I was really kind of annoyed that he downplayed injury that could take place from a taser. I don't think it hurts his case to acknowledge it. I just am annoyed that he downplayed it. But other than that, I think it's going as I expected. I think that Mr. Becker made a good opening statement. I'm kind of excited to hear the experts for both sides. I think that's where the case ultimately is going to lay, is in the experts. And I thought that Ms. Hamilton did a very good job also in her opening statement. I think she was more impassioned and I think appealing to making arguments. And I know that Mr. Becker had objected at one point in time, and I think the judge sustained. But my first thoughts are it's pretty much going as I anticipated. And I think it's going to come down to a battle of the experts.
And I wanted to ask you about those objections. Some of us who have watched trials, we typically don't see that super early in the case, but we saw 2 already. What are your thoughts on that? Is that something that is typical for cases like these, or just shows the passion and emotion from both sides?
I don't want to, it's not, that's a tough one to answer. Is it typical to have objections and opening statements? Yes, it does happen. It's not atypical. It's not like it's abnormal. It does happen. It doesn't happen a lot. When it does happen, it's usually because one side's like, look, you're really pushing past what we would call the boundary. Opening statements are supposed to be just that, statements. They're not arguments. Arguments come at the end. At the end, you can be as impassioned as you want in your closing argument, but it is called a closing argument.
And I want to ask more questions about the taser. You had mentioned that that's something that stuck out in regards to what Becker was saying. Do you think the use of the taser, what can happen when someone uses a taser, is that the focus of this trial, or will that bring a big impact to the jury's decision?
I think that is, I think what I heard in opening statement from Ms. Hamilton is that a big part of the defense is going to be what Mr. Schurr knew or thought about what was going to happen when Mr. Leoa got the actual taser in his hand. There was a new piece of evidence that I wasn't aware of, and she said it in opening statement, and so I'm hoping to see it in trial. Is that Patrick had actually switched hands from left hand to his right hand If that's the case, I think they're going to be arguing that changed the intent. At that point in time, and if Mr. Schurr was aware that he changed hands, that could change the analysis. And so I'm kind of excited to hear. They didn't say whether or not Mr. Schurr was going to testify. I'm kind of curious to see if he does. I think that in self-defense cases, it's hard to not have the defendant testify because he's going to have the most compelling story if there's a story to tell.
Well, Andrew, we have a lot more questions we'll be asking you throughout this trial. We appreciate you coming on quickly to kind of give us your thoughts as this trial begins.
You're very welcome.